Okay, so we'll go ahead and get started then. Again, I really appreciate everybody's patience with rescheduling this. We're going to talk today about POAs and the Fair Housing Act. We'll go through sort of the issues that we see come up most frequently, and then the process for responding. We should have a few minutes for questions at the end. I believe you can just drop those in the chat. So if you have any questions that you want me to cover at the end, I'll try to get to those. If I'm not able to get to them, I'll try to just reach out to you separately. So let's see. So this information presented today is based on the law as it exists today, August 19th. The information is presented for educational purposes, doesn't constitute specific legal advice for any particular situation. As we'll touch on in this presentation, the Fair Housing Act is one of those situations that we always recommend reaching out to your POA's attorney if you have a specific issue come up. So we'll go a little bit, just like a general overview of the Fair Housing Act at the federal level and the Texas level, and then we'll get into some of the protected classes that we see kind of come up more frequently, and then the really sort of hot button issues these days, which are assistant animals and group homes. We'll talk about accommodation requests generally, and then retaliation as it relates to fair housing activities. So the Fair Housing Act at the federal level was adopted by U.S. Congress in 1968. This is part of the sort of overarching Civil Rights Act. So it's been around for a long time at the federal level. The Fair Housing Act itself doesn't contain that much detail. A lot of the detail that we based opinions on for our clients are based on the sort of supplemental guidance that is issued by either the Department of Justice or the Department of Housing and Urban Development, which is a huge body of guidance that is also subject to change at any time. As with any other legal issue, we also look at case law to see how the courts are interpreting and applying that guidance. So there is sort of a lot outside of just the statutory text to look at. The Texas Fair Housing Act, on the other hand, was adopted in 1993 as a sort of part of the property code. It's substantively very similar to the Federal Fair Housing Act, and since both apply to POAs, those minor differences aren't necessarily very important, so I'm not going to really get into the weeds on that today, but do want to make you aware that there was both a Texas statute and a federal statute. So the Fair Housing Act is an anti-discrimination statute, and it prohibits discrimination in the context of housing on specific protected classes. So those are race, color, religion, sex, familial status, national origin, and disability. As of a few years ago, there was a U.S. Supreme Court case that interpreted the protected class of sex in the employment context to refer both to gender and to sexual orientation. So, the conservative assumption is that that's going to apply in the fair housing context as well. So, with those protected classes in mind, the Fair Housing Act prohibits discrimination in the terms, conditions, or privileges of a sale or rental of a dwelling, as well as the administrative administration of community facilities or services. So things like your common areas. The guidance specifies that this applies to a property owners association's application of its restrictions or policies. So, while a lot of the guidance really focuses primarily on the landlord-tenant relationship, it is very clear from the guidance that it applies to POAs as well. So in addition to prohibiting discrimination, it does also prohibit retaliation, which we'll talk about. So there are two primary types of discrimination claims. The one that we see most commonly is referred to as a disparate treatment claim. This is an individualized, intentional discrimination. So, a specific homeowner is treated differently, worse because of their membership in a protected class. This is a situation where the discrimination, again, is intentional. It's very clear that, this individual is being targeted because of their protected class. A disparate impact claim is a little different. The discrimination may be entirely unintentional. And what we're really looking at is a case where you have what's called a facially neutral policy. So something that on its face doesn't look discriminatory. It just looks like any other policy. But the impact of the application of that policy is that it negatively impacts a group of people based on their protected class. So let's see, an example that's been in the news in the last few years is there was a POA in the DFW area that adopted a policy. It was a leasing policy that explicitly said that a homeowner couldn't lease to somebody who was paying with a Section 8 voucher. A fair housing complaint was filed by some of the homeowners arguing that prohibiting Section 8 vouchers had the impact of affecting racial minorities more so than white renters. That escalated all the way to the Department of Justice, or I'm sorry, it may have been HUD, filing a lawsuit against that association. In that case, we actually had sort of both disparate impact and disparate treatment claims. You know, the argument was that the facially neutral leasing policy had a negative impact on minorities, but there was also some discovery to suggest that that impact may have been intentional. But disparate impact in general is going to be unintentional and have a negative impact on a group of people rather than a specific person being targeted. So one of the protected classes is religion, and the Fair Housing Act provides that, you know, you can't threaten, intimidate, or interfere with persons in their enjoyment of a dwelling because of religion. I wanted to bring this one up because a lot of people might be familiar in the employment context, which is under Title VII of the Civil Rights Act, so a different portion of the Civil Rights Act, that, you know, an employee in certain circumstances may be entitled to a religious accommodation at work. So for example, you know, you have mandated work times, but you need to take your breaks at different times because you're supposed to pray at certain times of day. That could be a situation where a religious accommodation comes in the employment context. There is no mere requirement to grant a religious accommodation in the housing context. So there's no, you know, when we talk about reasonable accommodations later on, that's really referring to disability related accommodations. Religious accommodations don't come into play for the Fair Housing Act. But I did want to point out that you still have Section 202.018 of the Property Code, which is that religious display statute. So just because the Fair Housing Act doesn't come into play doesn't mean that you don't want to stop and evaluate, you know, if a homeowner is requesting something related to their religion, specifically if it's the display of certain items on their property that might otherwise violate the restrictions. Familial status is another one. I think it's fair to say that a lot of people don't necessarily know what this means when they first see it. I certainly didn't before I started practicing law. It really refers to discrimination against people with children. So that could be anybody under 18, any child under 18 who's domiciled with a parent, with somebody who has legal custody, with just a temporary designee with the parent's written permission. It could be a foster kid. It could be, you know, even if the child hasn't been born yet, sort of discrimination against pregnant people. The idea is that this is intended to prevent people from trying to keep children out of their communities. So same sort of language. It prohibits discrimination against individuals in the sale, rental, or financing of housing because they have children who are under 18. There is an important exception to this rule, which is these 55 and up communities. Some of y'all might be familiar with. So there is a separate statute. It's the Housing for Older Persons Act. HOPA is what a lot of people will refer to it as, that carves these 55 and out communities out from the Fair Housing Act, particularly with respect to familial status discrimination. It had certain occupancy requirements saying, you know, a certain percentage of your homes have to be occupied by somebody who's 55 and up. There's these sort of biannual requirements to certify that you're complying with those requirements. So, you know, it is a narrow exception, but that's, you know, one of the questions we get a lot is, well, what about these 55 and up communities? They are exempt by statute. But, you know, at the end of the day, familial status discrimination is referring to treating families with children worse than adult-only families, making statements that indicate a preference regarding children. But the one that comes up the most often is having rules or restrictions that unreasonably limit children, especially when it comes to access to common areas. So one of the examples would be, and you know, it's very unpopular that this is the example we provide, but Adult Swim is one that we get questions about a lot. There is I want to say like a 1994 or 1995 advisory opinion that was issued by General Counsel for Housing and Urban Development, essentially saying that they consider Adult Swim hours to be facially a violation of the familial status discrimination statute. Their argument is that limiting children in that situation is not related to a health or safety concern. It's just wanting to have a certain time where children aren't allowed to access the amenities. So, the ones that come up are rules that require parental or adult supervision beyond an age that, you could argue is related to health or safety. Rules that set age limits on use of the common areas, which comes up most frequently in pool rules, and then curfew rules, things like that. So what do you do about that? Try to remove anything that suggests it's based on age. So, Adult Swim, a lot of times people will designate lap swim hours, or anybody can use the pool, but it's, the lanes are going to be out. It's going to be used for lap swim only. Maybe tailoring instead of saying no unaccompanied minors in the pool. The advisory opinion recommended changing that to requiring competent swimmers to accompany somebody who's not a competent swimmer. A lot of our associations will try to sort of limit it in age. That's not just minors, but maybe you have to be, if you're under 12, you have to have an adult with you, for example. The tough discussion we have with a lot of clients is that, typically not wanting to allow unaccompanied minors in the pool is because there are health and safety concerns. That children, aren't always great swimmers, that, it increases the risk of harm to the child, potentially death, even, unfortunately, almost every summer, somewhere in the country, a child drowns in a community pool. It's a tragedy every time. And ultimately, the exposure to an association for something like that is greater than the potential exposure for a violation of the Fair Housing Act. So sometimes you're in a catch-22, and it's just an evaluation of what level of risk are we willing to take. Do we limit minors in the pool with the understanding that it's facially a violation of the Fair Housing Act, but it might prevent drownings? That's a discussion to have with your attorney. Another one is, saying kids can't play in the streets. I don't know that I've ever seen a rule that says that, but we have seen particularly condo associations in a few circumstances get hit with rules requiring children to be accompanied by an adult on the common area or on the common elements, which include hallways and things like that. There are better ways to draft a rule that addresses that issue. Sometimes they just aren't really drafted in a way that really makes sense. So this is a real example that we've seen. Persons under 21 years of age are not allowed use of the clubhouse unless accompanied by an adult. Well, legally, an adult is a 21-year-old, is anybody over 18 or older. So, the effect of this rule is, if read literally, is if you're under 21, you have to be accompanied by somebody who's, over 17. There are better ways to draft some of these rules if you have a specific issue you're dealing with, involving your attorney, to kind of make sure that it's being drafted as narrowly as possible and in a way that's going to be effective for you. Disability is the one that we see come up the most. This is where those reasonable accommodations come into play. I do think it's important for POAs to understand that the Fair Housing Act's definition of a disability is much broader than most people assume. So generally, it would be a physical or mental impairment which substantially limits one or more major life activities, but it also includes a record of having such an impairment, or most interestingly, being regarded as having such an impairment, even if you don't. So it essentially means that if a POA discriminates against somebody because they think they're disabled, but they turn out not to actually be disabled, that could still be a violation of the Fair Housing Act because the intent was to discriminate against a disabled person. Very, very, very broad definition. So again, prohibits discrimination in the terms, conditions, privileges, or sale of a rental or dwelling. And so this is where the reasonable accommodation comes into play. So the idea behind the Fair Housing Act and the requirement to grant reasonable accommodations in certain circumstances is that there may be situations where a disabled person needs an exception from a rule in order to be able to fully use and enjoy their dwelling in the common areas. And so that's sort of where this question comes into play. Or is the person entitled to an accommodation? So the example that was in our newsletter this month, which I'm going to just briefly touch on, is hoarding, which, because it's now been given a diagnostic criteria by the American Psychological Association, very likely qualifies as a disability, in that it could be considered a mental impairment that has a negative impact on major life activities. And then ultimately the question in most hoarding situations is going to be, is this a health and safety issue for the community? Is like a rule even very clearly being violated, or is this really a neighbor dispute where somebody just doesn't like the way their neighbor's property looks? That's kind of the first question. Is it even something that POA should be involved in? If so, what rule is being violated? What options do we have to enforce it? There's a case that we talked about in the newsletter article, which was a case out of Washington, D.C., where it was a tenant who was the hoarder in an apartment. And ultimately the court held that the landlord should have kind of worked with the tenant to find additional resources, or when the tenant did identify a resource, given her the time to let that work, kind of it was a charitable organization that offered to come in and clean. But as the condition of that, they required her to be able to show that she would be allowed to continue living in the space. And so that required some participation by the landlord. But ultimately, it just, hoarding situations are going to be a very interactive process where if you're aware of community resources you can suggest, or if, maybe the owner needs a little more time than you would normally give to cure a violation, that you're kind of keeping that dialogue open. The big one that comes up the most is assistance animals. This is going to be those emotional support animals, service animals. We have a chicken as the picture here because we've dealt with a lot of emotional support chicken requests in the past several years. But a service animal and an emotional support animal will both qualify as assistance animals under the Fair Housing Act. So in the case of the Americans with Disabilities Act, which applies to public accommodations like stores and restaurants, that's really limited to service animals only, whereas the Fair Housing Act has a more broad definition to include these ESAs. And so a service animal is specifically trained to provide a service to a disabled person. So the guidance on assistance animals refers specifically to dogs only. This would be something like a service animal that provides, guide services to a blind homeowner. That's sort of the most obvious example. An emotional support animal, on the other hand, doesn't have to be specifically trained. It just has to provide emotional support that alleviates one or more identified effects of the disability. So, you hear a lot about it. Emotional support animals helping with anxiety. Sort of the most common. An emotional support dog is not necessarily trained to alleviate anxiety. It's just the fact that having the animal around has that effect. The default rule is that assistance animals are common household pets. The examples they give in the guidance are dogs, cats, birds, rabbits, hamsters, and turtles. And then anything other than that is considered what the guidance refers to as a unique animal. So the example they give for that are barnyard animals, reptiles, monkeys, kangaroos. I have yet to see a kangaroo, but the day is young. Unique animals require a higher burden of proof. So I'm going to kind of jump ahead in the slides and talk about what kind of documentation a POA can ask for when a homeowner requests a reasonable accommodation. Generally, it's going to be reliable documentation that the person on whose behalf the request is being made has a condition that qualifies as a disability under the Fair Housing Act. And then also documentation kind of showing the connection or the nexus between that disability and the request that they're making. Sort of like, how does the request that they're making serve a disability related need? Now, you can't always ask for that documentation. So if the disability is readily apparent, or if the disability related need is readily apparent, that limits your ability to ask for documentation. The most obvious example would be, let's say, a homeowner who the association knows to be in a wheelchair has said, my driveway is too narrow for me to get in and out of an accessible vehicle. I'm requesting an accommodation to expand my driveway. In that case, both the disability is obvious because the association knows that the owner uses a wheelchair, and the disability related need is obvious because, they've explained that it's to be able to get in and out of an accessible vehicle. In that case, you would not ask for documentation. But assuming you're in a situation where you do get to ask for documentation, or if there's a unique animal involved, there is sort of a higher burden of proof for a unique animal. They would need to show that the specific breed of animal or type of animal or the specific animal in question is the only animal that's able to provide that service to this owner. And so, when we get these emotional support chicken requests, when we get requests for goats, when we get requests for pigs, these are the sorts of things that an association can ask for. Notably, you can't deny a service animal or an assistance animal, I should say, based specifically on its breed or its size. So if you have, and I'm referring to common household pets here, so dogs, for example, you can't say you can't have this emotional support animal or service animal because it's a pit bull and we don't allow pit bulls, or, because the dog weighs 60 pounds and our condo says you can only have dogs up to 20 pounds. You would have to show that particular animal in question, presents some sort of risk to the health or safety of others. So if the pit bull in question has bitten somebody or has a record of injuring people, or if, has damaged people's property, then you can evaluate whether or not to allow that assistance animal. You can say no, it's no longer a reasonable request, but you can't just flat out say all pit bulls are banned, because in general, the sort of misconception is that pit bulls are going to be more likely to cause damage or hurt somebody. So again, the questions that you're allowed to ask for documentation related to is, does the person have a disability and a disability related need for the accommodation? If the disability is not readily apparent, you can ask for that information. Maybe the disability is apparent, but the disability related need is not, so you can ask for like that part of the documentation, but not documentation of the disability itself. The association is not ever going to be entitled to ask for specific medical records. So usually you're requesting a doctor's note or some other documentation from a treating healthcare provider, but not for, their actual medical records. So another one that has been seemingly, at least in my practice, on the rise lately is group homes. The ones that we've seen most commonly lately have been homes for patients with Alzheimer's, hospice facilities, physical rehab facilities. These are facilities that provide care for people who have disabilities, but don't necessarily require, hospital stays or sort of a more institutional facility. And these facilities are often entitled to reasonable accommodations from single family use restrictions. And, the response we get is, but it's a commercial or it's a business use, but there are all these people who are not related living in this home. It is facially, indisputably, a violation of the single family use restriction to operate a group home. But the Fair Housing Act provides that, if the group home meets certain requirements, that they're entitled to a reasonable accommodation from that restriction. It's very unpopular with homeowners. It's very unpopular with POAs. Unfortunately, that's what the guidance provides. So this is a situation where if you have a group home move in, we strongly encourage reaching out to your attorney to make the initial request or to guide you through making that initial request before you start sending violation notices. Now, this doesn't mean that they get to violate every rule that the association has. If the accommodation has been granted to allow the group home to operate, but you're having problems with street parking, with trash, with noise complaints, with these other issues, those really need to be evaluated on a case-by-case basis with your POA's attorney, because there may be certain rules that they're entitled to an accommodation for, and there may be others that they're not. And so, they can still be held to certain standards. But generally speaking, there there are a lot of circumstances in which a group home is entitled to operate in a single family neighborhood. Now, not all group homes are protected by the Fair Housing Act. So that's why we, encourage you to get your attorney involved early to make that evaluation. An example of one that's not protected would be like a halfway house or transitional living for somebody who's just gotten out of prison. That's not a disability. It's not a home that's designed to cater to people with disabilities. So that is not a home that would be entitled to this accommodation. Reasonable accommodation. More generally, we've already talked about it in the context of assistance animals. There are really two sort of categories. One is a true request for reasonable accommodation. That's a request for an exception to an existing rule, policy, practice, restriction. And then there's a reasonable modification, which is a request of structural changes to existing premises. So it can get kind of murky to tell what's what when you're dealing with an ACC related accommodation request. The question is really, is what the homeowner is ultimately asking for an exception from a rule. So while on sort of first glance, it may appear to be a modification because they're asking to make a structural change to their property, what they're really asking for is an accommodation from an ACC rule or from a provision in the restrictions. And so that would really fall back into that accommodation category. Whereas reasonable modifications are most likely to involve common areas. So something like a wheelchair ramp for a clubhouse or something like a lift for the pool, those would fall into that modification category. It is important because the guidance is different on who's required to pay for the related costs for a modification versus an accommodation. So for a modification, it's going to be made at the expense of the person making the request or at the expense of the disabled person. There is a very important caveat for that we go over with our clients a lot, which is that if you require the homeowner to cover those costs, the association doesn't get any control over the contractor that's selected, over the contract that gets signed. The insurance are required to carry aesthetically what the modification is going to look like. So you're giving up essentially all control over the installation process. But if a modification is made to the common area after it's been installed, that expense to maintain shifts back to the association. So a lot of times our clients will sort of voluntarily pay for these modifications, even though they're not required to, because they do want to have control over those issues. And especially if, especially aesthetics come in a concern a lot, but also just making sure it's a reputable contractor. Costs for accommodations are at the association's expense, but there's usually not a hard cost associated with with granting an exception from a rule. So the cost is really more of a concern in the modification setting. So, we've already talked about supporting documentation, but part of the evaluation is also whether the requested accommodation is actually reasonable. It's called a reasonable accommodation for a reason. If the accommodation is going to cause an undue burden, the association doesn't have to grant it. It could be considered unreasonable. This has a very specific meaning that's set out by the statute and by guidance. And so it's not enough to say, like, we don't think it's reasonable because, it's crazy for XYZ reason. It has to fall into this actual definition of an undue burden, which is that it would impose an undue financial or administrative burden on the association. It would fundamentally alter the nature of the association's operations, or pose a direct threat to the health or safety of others, or result in substantial physical damage to the property of others. So, this doesn't come up often. The example given in guidance is again in the landlord-tenant setting, so not directly analogous, but just to kind of give you an idea. The example was, if you have a tenant who says, well, I'm disabled and I can't get to and from the grocery store, I need you to provide a service to drive me back and forth. And the landlord's response is, well, that's not a service that we offer. We'd have to hire somebody to do that. We'd have to have this whole other person on our payroll. That's an undue financial burden, undue administrative burden. It's an alteration of the way that the landlord in that case actually operates. So that would be an example of a situation where you don't have to grant an accommodation because it wouldn't be reasonable due to the undue burden. In terms of responding to accommodation requests, the statute requires, or the guidance requires the association to do something called engaging in the interactive process, which means, if the request comes in, you don't just flatly deny it most of the time. If you think it's something that can be denied, you kind of engage in a conversation with the homeowner about alternative accommodations or, what other options might be available. But it also just means, take the request seriously, respond timely. The statute requires a prompt response, which the guidance has sort of interpreted as meaning 10 days is the maximum. So when you get a request and you think you get to, if it's a situation where you can request supporting documentation, making that request within 10 days. And then once you receive supporting documentation, making a decision on the accommodation within 10 days. That can't always happen for one reason or the other. If for some reason it's going to take you longer than that, my recommendation is just to make sure that you're keeping the homeowner informed, you're explaining what's going on, why it's taking longer. The unfortunate reality is a lot of time accommodations are requested after the fact, so after something's already been done. So this might look like pausing enforcement actions while the discussion happens about the accommodation request. So not accruing fines, not sending violation notices. You want to document any conversations with the homeowner carefully, and you want, ideally in writing. It's a lot easier if a fair housing complaint gets filed to attach an email showing that a conversation happened rather than asking the investigator to decide who to trust about, who said what on a phone call. That's not to say there can never be a phone call, but if there's a phone call, maybe you follow that up with an email saying, here's what we discussed. And then involve your attorney early and often when it comes to fair housing disputes. It's a lot easier for the attorney to kind of guide you from the beginning than to try to sort of backtrack on things. A lot of times violations are not bad faith. A lot of times the board might not realize that they're doing something they're not supposed to. And so involving your attorney early can just make sure that everything's done the way it needs to be done. All right, so retaliation, interference, and coercion. This essentially just says that if somebody exercises their right under the Fair Housing Act to request an accommodation, for example, or, to make a complaint if they think something discriminatory has happened, or if, somebody aids or encourages somebody else to exercise their rights under the Fair Housing Act, that the association can't retaliate against that person by, for example, targeting them for heightened, violation matters, or, trying to prevent them from running for the board, or trying to charge back the attorney's fees to respond to a fair housing complaint. These are all things that you just want to be careful about. Essentially, you can't treat somebody differently because they exercise some sort of right under the Fair Housing Act, even if ultimately, it was decided. So say, for example, the homeowner requests a reasonable accommodation that's denied because they never provide supporting documentation, or they make a complaint and it's found that no discrimination occurred. You still can't retaliate against them for making the complaint in the first place or making the request in the first place. So essentially says you can't interfere with the exercise of their rights. You can't coerce them not to exercise their rights. You can't threaten them. You can't intimidate them because of their decision to take action under the Fair Housing Act. So the best practices, association boards, we do encourage them to participate in regular fair housing training as well as managers. If a particular community is dealing with a lot of requests, maybe consider adopting a policy regarding the handling of fair housing requests just to make sure that it's done consistently. Determining whether your insurance is going to cover an administrative complaint. So your D&O insurance typically will cover responding to a fair housing complaint, but not, that is something you just want to confirm. And I'll kind of interject here just a quick discussion about what options the homeowner has if they feel like they've been aggrieved under the Fair Housing Act. The one that happens most commonly and that's the easiest to do is just to file a complaint. So this is an administrative complaint through whatever agency is responsible for investigating fair housing complaints in your part of the state. So that could be the Texas Workforce Commission. It could be the Civil Rights Division of your local city government. Sometimes it's just it goes directly to Housing and Urban Development to investigate. It's a form you fill out. It's short. It's easy to do without an attorney. You sort of, fill in your name and the name of the association and give a description of how you think that the Fair Housing Act was violated, and that's sufficient to open an investigation that the association has an obligation to provide a written response to. So, it's easy, it's cheap. That's what a lot of people will do, but it's not a prerequisite to filing suit. So in the employment context, if you want to complain about a discriminatory employment practice, in most cases, you have to file a charge with the EEOC before you can get a right to sue letter and file a lawsuit. For the Fair Housing Act, you can jump straight to litigation if you want to. So that is a possibility. Again, most people don't do that just because it's so easy to file a complaint that they'll typically start with that and hope, that a settlement is reached or that there's a finding in their favor. And then sort of the door number 3 is that the homeowner can file a complaint. The investigative body can determine that there's reasonable cause to believe a discriminatory action occurred. And then that investigative body can file a lawsuit against the association. They're the plaintiff in that case. They're filing based on the violation involving a particular owner, but the plaintiff is that investigative body. So that's sort of, you see that a lot less frequently. That is a possibility. So, D&O policies almost always will provide cost of defense for a lawsuit. So just making sure that it also includes those administrative complaints in case that's what's filed instead. And then, okay, so if an association receives a request or a complaint or, an allegation of discrimination, just making sure that that's considered and responded to timely, and that it's addressed promptly. And, again, getting your attorney involved early so you can make sure that all of this is being done properly. If an association is found to have violated the Fair Housing Act, there are potential civil penalties in litigation. There are potential civil penalties. There are, potentially the requirement to pay the other party's attorney's fees. There could be punitive damages. Notably, the federal statute that addresses volunteer immunity for individual board members does exclude violations of civil rights law. So a director who is found to have violated the Fair Housing Act could have personal liability for it. So it is a serious thing, and which is why, we really advise getting your attorney involved early. So just sort of a conclusion, fair housing law is not intuitive. It sometimes defies common sense. The guidance doesn't necessarily say what you think it would say. It's incredibly nuanced. It's very fact specific based on every situation. And the result is that it does sometimes require unequal treatment. So if you're a homeowner who doesn't have a disability, and you're not allowed to do something, but your neighbor is, because they're entitled to a reasonable accommodation, you may feel that accurately that the two parties are not being treated equally. But the idea of the Fair Housing Act is to sort of allow unequal treatment when necessary to even the playing field for disabled people. So, it's not always something that's very popular with homeowners, but at the end of the day, it is designed to sort of provide a leg up where needed. The hope is that you can identify these fair housing issues at least enough to know to reach out to your attorney, and then to avoid unnecessarily escalating disputes with homeowners by hopefully being able to reach a resolution early on. And I wanted to leave time for questions, which it looks like we have. So let me see if I can get back to the chat. Okay, I'm just going to start at the top. Age is not a protected class is the question. Not under the Fair Housing Act. It is in employment situations, but it's not one of the listed. It's not one of the listed protected classes in this context. And now you do have the familial status discrimination, which would come into play for children. But other than that, no. Is the HOA required to pay and provide governing documents in large type for a sight impaired owner? typically, I have not had that question come up before. I would say, I mean, it's not really an exception from a rule. So arguably not. I think it would be more a question of, complying with the request and, cooperating. We have run into situations before where we have advised clients to, consider, if you have a deaf owner, maybe having somebody who's available to sign or having somebody who can provide closed captioning. But it's not it's not really specifically defined in the guidance. So I would say it depends on the circumstances, but likely not something the association would have to pay for the cost of. Oh, there's Audrey again. We do apologize for any confusion regarding the date rescheduling. Again, I really appreciate everybody's patience with that. It was driving my husband to and from a dental surgery appointment. ADA requirements for common areas for tax exempt communities. So for most associations, the ADA doesn't apply, but if you have these publicly, if you have these common areas that are open to the general public, not just people in the community, you could be subject to the ADA. That could be a whole nother presentation, honestly. There could be certain construction requirements where you have to build the buildings to be accessible, depending on when they were built. So the accommodation discussion under the ADA is really an entirely different ballgame. So if you have an ADA request come up, I would suggest reaching out to your attorney, but for most associations, the ADA is not going to apply. I will say that if a homeowner makes a request under the ADA, even if the ADA doesn't apply, that's likely enough to trigger a response where you say, hey, ADA doesn't apply. We're going to consider your request to be a request under the Fair Housing Act. So just something to be aware of. They don't necessarily have to specifically say the words, I'm requesting a reasonable accommodation under the Fair Housing Act. If it's clear enough from the request that that's what they're asking for, you still have an obligation to respond. Now that we are required to allow political gatherings, etc., we have an open amenity center, and those might be offended that people gathering are part of a church group and praying. How can we prevent this from happening, or can we? So there is a new statute that requires an association to allow political candidates for office to come speak at their common areas that are generally open for, a homeowner to rent or to reserve. I wouldn't say that extends to religious groups. We typically advise against opening the community amenities for religious purposes or for really even political purposes that aren't covered by that new statute, just because you do run into issues where, a homeowner might say, you let this particular religious group, we're at the clubhouse, but you're not me, or they're being allowed to do this and we're not. And so you generally can, adopt amenity center rules that set limitations on the circumstances in which the amenity center can be rented. And it, with the exception of the limited applicability of that new statute, you can typically prevent use for political gatherings or religious gatherings. Okay, disparate impact claim. If the owners are able-bodied, but their child is disabled, must an accommodation be made for the minor child? Yes. So that's going to include really anybody who lives in the community. There's even some really broad language that just refers to somebody who's, affiliated. It's not the word they use, but essentially somebody who's associated with the owner of the property. So just because the person on whose behalf the request is being made is not a member of the association, if they are a member of the community, they live in the community, you're going to need to grant an accommodation for them as well. Age requirements for non-guard pool hours. Is it a safety issue? I think that's, if you don't have a lifeguard and you have just generally a rule that, minors have to be accompanied by an adult, that could be an issue. Because, a 17-year-old is probably, from a safety perspective, going to be fine. Narrowly tailoring that rule to maybe apply to either people who are incompetent swimmers or children under a younger age where it's easier to argue it's a health or safety concern would be ideal. And then it's really just that conversation with your attorney, the sort of balancing act of are we willing to risk violating this familial status discrimination statute if we think that it's necessary to prevent a child from drowning in our pool. As far as limiting ages and things, what about events held? If there's an alcohol-based event, for example, can you prohibit people under 21? Potentially, a lot of times what we'll talk about is, just having some sort of age verification where somebody who's over 21 gets a wristband, so you can make sure that people who are under 21 aren't drinking. If you're really concerned, if there's a real health or safety concern, that's a discussion you can have. But for the most part, if you're just trying to prevent children from getting their hands on alcohol, there are other ways to do that. That would be preferable. What about all the newer motorized bikes / scooters being on streets or sidewalks? Where does discrimination start? I need more information for that one. You don't generally have to allow motorized bikes or scooters on the streets or sidewalks, unless it's like a mobility impairment issue. Like if somebody has a motorized wheelchair, for example, that's kind of where that might come into play. Or if you're talking about familial status discrimination, because it's usually children operating those, I think as long as the rules being enforced equally against adults as well, that's, less of an age-based restriction, so you might be fine there. I just had to deal with an emotional support chicken, Chantel says. Haven't we all? We really thought a lot during the pandemic when people wanted to have fresh eggs. We were dealing with a lot of emotional support chicken questions. I will say our litigation section had some really good results on a chicken issue that escalated to a complaint. So we have had some luck pushing back on that. At the community pool, can you ask that an animal leave the premises if they're not a service animal? So you would need to allow all assistance animals, which would include emotional support animals, as well as true service animals. You don't have to let them into the pool. There's a provision of the Texas Health Code, I believe, that says that animals aren't supposed to get into the water. You would still need to allow them in the area around the water, but you don't have to let them into the pool itself. Are ADA service animals the same as emotional support pets? Is there a legal limit on the quantity of emotional support pets? And is there a limit on pets allowed at a home? Does the ADA or emotionals count? Do service animals or emotional support animals count towards that limit? So for purposes of the Fair Housing Act, service animals and emotional support animals are treated the same. There's nothing in guidance that talks about a legal limit on the quantity. I think that's where that reasonableness issue comes into question. We had a guy say he needed like 70 emotional support chickens. It's like you don't have an emotional connection with 70 of those chickens. You just don't. So that's something you can talk about, but there is technically not a limit on the number of emotional support animals that a person can have under the guidance. So it's really kind of a fact-based question. If an association has a limit on the number of pets a person can have, the guidance provides that emotional support animals and service animals are not considered pets for the application of those rules, and so they would not count towards that limit. So how does an emotional support animal get treated like a support animal? Or does an emotional support animal get treated like a service animal? And can you ask for documentation if they are trying to bring them into the common area? So yes, they are treated the same. If somebody is, maybe you have a rule that says no animals in the amenity center, that is the situation where they're effectively asking for an accommodation from that rule. So you could ask for supporting documentation, establishing that they have a disability and a disability-related need to have that animal with them. Can the number of live-in home care individuals living in a single home be limited? Or request documentation that they need more than one? Yeah, I think that's different than a group home. We see a lot of restrictions that say, if you have one full-time live-in caregiver, we're not going to count that as a violation of the single family use restriction. If they're saying they need more than one, it's really something different than a group home. I think you would be fine to ask for documentation related to that. Maybe they have somebody, well, I guess that wouldn't be somebody living with them if they had shift workers. But yeah, so if they're saying, look, you let us have one, but we need more than one, I think you could ask for documentation related to that. If the disability and the disability related need aren't apparent. How do you address amenity access with a group home? I haven't personally had that issue come up with, any of the group homes I've worked with yet. A lot of them are either like hospice facilities or, memory care facilities. And so they're really, the occupants are kind of confined in the home most of the time. Generally speaking, though, if they're able to show that somebody is a resident, I would think that the Fair Housing Act would require you to let them have amenity access the same as, an occupant of another home. If a homeowner installs handrails that others consider ugly, is that protected if they didn't go through the ACC? So I will say the guidance provides that, if somebody makes an initial request for an accommodation in response to, say, a violation letter, so they kind of wait until enforcement has started to ask for an accommodation, they lose the inference that they're acting in good faith. So, or the presumption that they're acting in good faith, I should say. So it does kind of hurt owners to ask for it after the fact, but it doesn't necessarily negate their right to the accommodation at the end of the day. If they provide supporting documentation, or they have a disability that is served by the installation of the handrails, you typically don't get to complain about the aesthetics. Now, if the association wants to require a nicer handrail or something that looks better, that increased cost would be on the association at that point. So, if the homeowner is entitled to the accommodation for the association says we want it to act, if we want it to look nicer, that's something that the association would have to pay for. What about a group home for mental disabilities? Is likely going to fall under that protection as well, provided, if the mental disability is considered a disability under the Fair Housing Act. We have an owner leasing a home to an individual, and the tenant is using the home as a recovery house, or we're required to request documentation. So generally speaking, the requirements of the Fair Housing Act will apply whether the request is coming from an owner or a tenant. So if it's a protected group home, that is something that would be protected even if it's being operated by a tenant rather than the owner. Recovery houses, if you're talking about like substance abuse recovery, it's a little more fact specific. Are they actively treating addiction, or is it just sort of a transitional living facility? If they're actively being treated for addiction, that is something that may be covered. But you would be entitled to request a comment, if you don't know how the home is being used, or you don't know if it's serving people that are actively, that have a disability currently, that is something that you can request information about. So if a landlord that rents out 5 individual rooms should not be considered a protected group home, likely not. I mean, if it's just like a boarding house situation where, they just have 5 unrelated people living in the house, but there's no disability related services provided, it's just 5 roommates, that would not be a protected group home. It's specifically talking about group homes that serve people with disabilities. Would a POA that has no dwellings still have liability rental practices of commercial rental business within it? I'm not sure I understand that question. So it would apply both to, if the question is, by dwellings, you mean single family dwellings, it would apply whether it's condos, single family dwellings, or like townhomes, for example. But commercial associations, so if you have a commercial association where there aren't any residential facilities, you wouldn't be subject to the Fair Housing Act because you wouldn't be talking about the provision of housing. There could be other issues like zoning, maybe, for example, might require you to allow like a group home, for example, but the Fair Housing Act wouldn't come into play in that situation. Will you share the slides with us? Andre, do we send the slides after the presentation? I think we make those available. Is that right?
Yes. Yes, we'll send an email. It'll have the slides and the thank you email. Yes.
Okay, perfect. Thanks. Chairlifts for private HOA pools for disabled homeowner requiring, that would fall under that reasonable modification. So since it's a structural change to the common areas, the association would be required to allow it. but the association would be able to decide whether it wants to require the homeowner to pay, in which case it loses that control over the installation. Or, you know, if they want to require, or if they want to pay for it themselves. Can you clarify the verbiage Adult Swim is not allowed? Something we should not be using. The language should be changed, is the question. Yeah, so straight up Adult Swim has been interpreted by HUD to be a violation of the Fair Housing Act. So we don't recommend Adult Swim hours. You know, if there's something else that you want to accomplish by having Adult Swim, maybe it's a time when you don't have a lifeguard or a time when it's used for lap swim, kind of changing that verbiage a little bit would be an option. Excuse me. The condo HOA approved service animal and or emotional support animal are still required to follow rules of the association related to pets, even though they're not defined as pets per se, correct? Yeah, so, you know, things like having to pick up after your animal, for example, there are limited situations where leashing rules might not apply if the service provided by a service animal requires it to be off leash. So like a true service animal. But that's a really, really rare circumstance. For the most part, yes, they would still be subject to those rules, but they wouldn't count towards things like pet limits or weight limits. We are a high-rise COA that has a no pets policy. Can we prohibit ESAs? Can we require them to use a service elevator? We require DNA samples for ESAs like communities do for dogs to test waste that is not cleaned up. So you can't prohibit ESAs because they don't technically count as pets under the Fair Housing Act. We don't typically require things like requiring to use service animal or requiring them to use service elevators, for example, unless there's a specific reason related to health and safety that you're concerned about. You know, if the particular animal in question has caused some issues. If you have a written rule about requiring DNA samples for emotional support animals, I don't see why not, because enforcing the rule that pet waste be cleaned up is a health and safety concern. So that's, you know, I think that's reasonable to continue enforcing that rule. Can a condo association prohibit a convicted felon from moving into a high rise? That's a more complicated question. We typically recommend getting involved in we typically recommend against getting involved in the approval of specific tenants, just because there's a lot of potential liability there. We have seen people try to argue that restrictions on felons have a disparate impact on men. Their argument is that, you know, and I haven't looked at the data, the argument is that, you know, men are more likely to be convicted of felony. And so this has a disparate impact on men. That argument has not been successful thus far. But the reason it hasn't been successful isn't because the court just wholly threw out that argument. It's been because the plaintiffs in those cases did not provide sufficient data to back up their allegation that it caused a disparate impact. So that is something that could develop in the future. But for the most part, there's a lot of risk involved with, you know, accidentally mislabeling somebody as a felon because there's a mistake in the criminal background search, or, you know, whatever the case may be, accidentally letting somebody get through who shouldn't under a rule that says no convicted felons. You know, we really like associations to kind of stay out of that business if possible. Certainly, you know, that's something you can talk about in the condo setting. In single family setting, that's not something the association can do by statute. Not really allowed to approve or disapprove a particular tenant. If the board provides a variance or accommodation, or other owners entitled to an explanation or details surrounding the accommodation. You know, typically our request for supporting documentation includes some language saying that the information isn't going to be shared unless necessary or required by law. I'm fine with the association providing a very generalized statement that, look, sometimes an association may be required to provide a reasonable accommodation under the Fair Housing Act without going into specifics about a particular owner. We end up having a lot of sort of generalized discussions like that when a group home moves into a community and a lot of neighbors are contacting the management company, but we don't recommend going into details about a particular owner situation with other homeowners. Does complaining to the owner of an ESA about their ESA being noisy or smelly or messy count as retaliation? What if I make fun of them for needing an ESA? I would not make fun of them for needing an ESA. That could that could be problematic. But you know, I think, you know, we talked a little bit about the fact that you're entitled to an accommodation to have an animal doesn't mean necessarily, or to have a group home doesn't mean that you're exempt from all the related rules. So if a person's emotional support animal is committing a violation that isn't just based on the fact that the animal exists, if their waste isn't being picked up after, if they're an animal that, you know, there's no reason they can't be on a leash based on the service they provide, that they're not being leashed, those are still rules you can enforce. How do you address hydrotherapy spas prescribed by a doctor in a community that doesn't allow above ground pools? So, you know, this is something that we've seen come up. If a homeowner provides supporting documentation, it's reliable documentation that they have a disability and they have a disability related need for the hydrotherapy spa, it's been approved by a doctor. You may be required to grant an accommodation from the requirement or from the restriction against above ground pools. But you know, these are situations where you could talk with the owner about setbacks or screening. Again, aesthetic considerations that cause an increased cost to the homeowner is something the association might have to cover, but you can still have those conversations about you know, what can we do to sort of honor the intent of the rule while still granting the accommodation, you know, make it less unpleasant to live next to you, I guess. So our last question, which is good because we're just about out of time. What if a tenant/owner says they need a window AC unit in a condo window due to a health issue, which is against the rules? Again, you know, if they provide sufficient documentation, and there's not a safety concern with having the AC unit, that is something that might be, you know, that may be a situation where you have to grant an accommodation. Okay. Oh, sorry. One more come in and then we're going to have to stop. Does ESA documentation need to be from a doctor or mental health professional in Texas or the USA? Technically, the guidance refers to just somebody who's familiar with the person's condition. It does typically, in our experience, come from a doctor or mental health professional. I will say there is some guidance that was issued a few years ago that says these sort of websites that will just let you register your dog and then it prints out a certificate saying this is an ESA. That's guidance specifically provides that alone is not sufficient. So you do need more reliable documentation than that. So if an owner like hands you a certificate, they print it off a website, you are entitled to ask for additional information. Again, it's, you know, so Andre will send out, or our marketing team will send out the slides. I think that also will include information about CE credits and all of that. I appreciate everybody joining today. Feel free to reach out to me if you have any additional questions. I'll put up on the slide real quick. That's a QR code you can use. That'll have my contact information, my email, and my phone number and stuff. And so just don't hesitate to reach out if you need anything. And thanks again so much for joining. And I hope you'll have a great day.